Speaking.
Hi, this is Lynette with Judge Cole. How are you?
Pretty good. How about yourself?
I'm good, thank you. We're having a little bit of a technical issue this morning, so we're going to have you by speakerphone, okay?
Okay.
Okay, Judge Cole will be right with you. One second.
Yes, ma'am.
Hi, Mr. LeBlanc, can you hear us?
Yes, ma'am. Can you hear me?
Yes, we can hear you. 1 second. Let me call the case.
Good morning. Hi, Mr. LeBlanc. How are you?
Pretty good, sir. How are you, sir?
I'm all right. So, are you getting together your motion for summary judgment?
Yes, sir.
Oh, good. All right. And it's due when? Soon.
Yes, sir. I believe its due date is the 16th.
Okay. So we'll be looking forward to that, and we have a schedule set up for responses and replies, can we? Or no? No. Okay. And we'll talk about that. Let me deal with first your various filings. You have a motion to request jurisdiction in accordance with the diversity rule on 28 U.S.C. 1332. Do you have that one up as the number?
The computer at all.
Okay. Well, the motion about jurisdiction, I'll deal with that when you file or when I'm required to deal with the summary judgment.
Okay.
I'm not going to do that in advance, but I understand your attentiveness and eagerness, and I appreciate it. So, the motion to request jurisdiction in accordance with the version of USC will be decided at the time the motion for summary judgment is decided.
Yes, sir. Yes, sir.
All right. Then we have a letter. Well, let me go to the next motion, which again I don't have a number in that. And that's the motion to request clarification from the court regarding defendant status, and that's done. I did that. I think the last minute order dealt with that.
Okay. Okay, Your Honor. If I may.
Sure.
Okay. The reason why I asked for that clarification is I submitted the documentation, what you referred to as documentation, the court transcripts, and the court transcripts clarified that it was to remove the document. Now, I'm not but so privy to the ends of courts, and I'm still learning things. So hence why I'm asking for the clarification, because based off the case law that I've reviewed, though not exact, somewhat similar circumstances when the answers have been removed and nothing had been put in its place that put the party at default. So that's what I didn't understand. If the document was
because you're not a lawyer, I really do understand, but sometimes it makes things harder. It's kind of like if you or I were put in a hospital setting and trying to give doctors advice. We have limited knowledge. Anyway, though, I think the last minute order dealt with this. It isn't that your issues aren't going to be decided. It's just that it's inappropriate to do what you're doing now. But it'll be taken care of. I think all will be clear after the motion for summary judgment is filed. Now, hold on. Then I've got a letter from you dated 27 November. I'm pretty sure from my review of the docket that this actually got. Oh no, it is. No, I've got judge's copy December 4th, Tom Bruton Court, but I think this got filed, didn't it?
The November 27th letter. Is that what you're referring to, sir? Yes, I believe it did. I believe it did get filed on the docket. I'm outside in my car, so I don't have access to the docket entries.
I'm pretty sure it did, because when I looked at it, I was going to do something, and then I looked at the docket, and I saw, lo and behold, it's on the docket. So I don't know exactly what your situation is. I know it's hard for people who are neither lawyers nor understand the system to file things. I confess to you, at this stage of my life, would not know how to file anything. And I swear to you, that is the absolute truth. I wouldn't know what to do. I don't know how they just magically appear. So your dilemma is one that I truly am sympathetic with. But I can't do anything about it because somehow you're getting stuff filed. I don't know where you're sitting at the Bruton and it gets filed on I don't know what you're doing. Things are getting filed.
Right. Well, I'm sorry.
I have the authority to excuse you from not being a participant in the system. And I see lots of pro se litigants, although they're mainly in jail, and they somehow, it's true, and they somehow get things filed. So I don't know what your situation is, but things are working out okay.
Greatly appreciate it, Your Honor. A lot of the times it just happens to work out at some point, and I do have to contact the courthouse often to chase down where they are. For example, I had a motion in response to the defendant's motion to bar that arrived via express mail to Chicago yesterday. However, since the mail clerk, I believe, only goes once a day around 8 o'clock, that letter was not available to even be considered posted to the docket. I'm hoping it'll be picked up today and be posted to the docket, and that's actually what I sent to your chambers directly, as well as sent an electronic copy to Defendant Marassa before the close of business yesterday. There is a mailed copy in the mail for him as well, but it was just to try to get things there. So I'm trying to anticipate as best I can while working on the motions that I'm supposed to be working on, and trying to get things out. So sometimes it works out, but my biggest thing is if I am able to do the electronic filing, the 24-hour rule seems to be my biggest potential hang-up, because it would cost a fortune in order to get a lot of those motions, or depending on what the motion is and how many pages it is, to get it to your chambers within a day.
Oh, I don't really. You don't have to worry about. I mean, I know that we're supposed to get courtesy copies, but if you're out of town and you put a courtesy copy in the mail to me, it'll get here when it gets here. We really do pick up things off the docket. I happen to be old-fashioned, and I don't like reading online, although I read cases online because I have gotten used to that. But motions and stuff, I don't read on the computer. I read the paper. I'm just old-fashioned. So, but you don't have to worry. If it doesn't get here a day or two, it'll get here, and it will be considered.
Okay. Thank you, Your Honor.
Okay. Now, let's talk about. Can I ask you a question? I don't know if is there some paper that you filed? Well, let me ask up. Is it something you filed in which he has estimated for you his damages? No.
Actually, Your Honor, if I may, there was actually an estimation of damages, but it didn't take place before Defendant Marassa. It was actually given to Attorney Kirkulis actually multiple times throughout the course of these proceedings, generally stemming back, I think, as far as 2016, then again in 2017 when Judge Martin...
Haven't you, Mr. Blanc, ever filed a statement, because the rules require this, in which you estimate how much you've been injured? In other words, at the beginning of the case, there are disclosure requirements that require that plaintiffs tell the other side what they think their case is going to be worth. Not that they're held to it necessarily, but they give an idea: $1 million, $10,000.
As far as I'm aware, it's just based off of the initial filing in order for it to be moved to federal court. Because
how much did you ask for in the initial file, or did you just say over 75,000?
Yeah, it was the over 75,000, and then as Judge Martin did have us do an assessment of the strengths and weaknesses of our cases, and during that time, I actually did produce documentation as to a rough estimation as to what it would cost stateside, and then once I got the Costa Rican doctor, I actually submitted those bills and then gave a comparative that, as you can see, it's much cheaper if I'm able to do it in Costa Rica than here.
Mr. LeBlanc, all I want to know, and we make it simple, it's roughly, and no one's in any way at all. I just want to know roughly what you think your damages are.
Well, they're currently over.
Mr. LeBlanc, just give me a number. That's all I'm asking.
Okay, a number, Your Honor. I would have to say that my damages will probably be well over $650,000. That's just for medical. That's not including anything else.
Mr. LeBlanc, that's all I think we need to know. And so I assume this case obviously is not going to get settled. But anyway, so you're going to be filing a motion for summary judgment. Mm-hmm. The defendant, those often. Well, let's see what you file.
Okay.
The defendant will then file his response, and there's a schedule in place. Yes.
No,
there is not. Oh, okay. So let's create one right now. So December. What did I say? 19th, 16th.
16th, I believe you said December 16th.
That's what the last order provided, because you've got continuances. So December 16th will be the motion for summary judgment. How much time do you want to respond? 30 days?
Yes.
Let's take 45.
Okay.
And I'm giving him more time, not because he's the defendant, but because of the intervening holidays.
No, I understand, Your Honor, and that's kind of a similar situation we found ourselves in the previous year when I was propounding interrogatory, so I understand.
Okay, so 45 days on that from December 16th.
January 30th?
Okay, January 30th will be the response, and 14 days thereafter, Mr. LeBlanc, to reply if you want to.
Okay.
You don't have to, but most people do.
Yeah, I'm pretty sure I probably will. I like to be as thorough as I can.
Okay. So that will be the schedule, and then I will consider it, and I'll have you guys come back. No? Okay. I'll have you guys come back in 90 days, sir.
90 days?
If I get to it sooner, I'll let you know, but this will give everybody plenty of time.
Yes, Your Honor, understood.
From the reply group state. Yeah, and that'll be a ruling also. Status and ruling. So, let's see where we go. If your motion for summary judgment is not granted, and lots are not, some are, then we have to talk about a trial date. The defendant is not going to be following a motion for summary judgment. No. Okay. I'm sorry? Oh, okay. Wait, I'm not sure I understood what you just said. Tell me. Oh, I didn't realize that. Okay. So the summary judgment, so the summary judgment, people keep changing, So the summary judgment, Mr. LeBlanc, should not be about their liability. And liability has been admitted on record? Yes. Okay. Do you understand that, Mr. LeBlanc?
I'm not 100% sure, Your Honor.
Thank you. In other words, the defendant, in many cases, a defendant will say, yes, the accident happened, almost all cases, but it's not my fault, or I'm not liable. And point the finger wherever they point the finger, and they say, if you can't. So If you get past liability, then you look at damages and you say, okay, the defendant did it, and now what are your damages, Mr. Plaintiff? You don't have to go through the intermediate or first step, I should say, of proving liability because the defendant has admitted it's responsible. The only question for you is how much do you get? Do you follow that? Don't devote yourself at all to proving in the summary judgment papers that they are responsible. They've admitted their responsibility. Okay. You're going to claim. Let me finish. You're going to claim $800,000 in damages. They will turn around and they will say, "No, you have zero damage, or you have $10,000, or you have They'll pick a number, and let's talk a bit about this. You're free to file anything that you want, but I have to tell you, the idea of you're getting summary judgment on damages and how you were injured is pretty slim. Has there been medical discovery taken in this case?
One doctor's deposition from the doctor, not anything else that has happened.
That's correct. That's correct. The defendants haven't examined me, haven't done anything.
LeBlanc,
yes, ma'am. Yes, sir.
You have to not keep talking.
Okay. Sorry, Your Honor.
The greatest thing in life is to be a good listener.
Understood, sir.
Always tells me. It doesn't call me happily. I am saying to you, the notion of summary judgment being granted on damages seems very, very unlikely. You would have to prove that there is no material fact that exists about an injury, admittedly, an injury to you. In other words, the value of that injury. Let's say you broke your arm, and you say, well, I want $1 million for my broken arm. And the defense says, well, it's absurd. Kids break their arms every day. It's not worth $1 million. Maybe it's worth $1,000. You would not get summary judgment, not because they're not liable, but because there are open issues of material fact that divide you and the defendant. In other words, you have a disagreement. You think it's worth one thing, and you got to prove it. And they'll say, no, it's not, and they'll have some evidence, I assume in the form of experts, who will say something else. It's very hard for you to get summary judgment on the value of an admitted injury. That doesn't mean you can't try. Somebody's told you you can. I'm not sure I would have let you do that, but that's neither here nor there. So just be very, very careful. Don't waste your time proving liability. It's admitted.
I understand that aspect of that, Your Honor. I do humbly disagree with the chances of being able to get that granted, and I'll keep that information in the motion for summary judgment. But I will definitely make sure it focuses primarily on what you've laid out, that the focus should be since they've admitted liability.
Simple example: you say, "I broke my arm." Mm-hmm. Then you file an affidavit or affidavits that basically underscore the idea that your broken arm is worth $100,000. Mm-hmm. They will have affidavits from, it'll be not only from your deposition, but affidavits, declarations from doctors who will say little kids break their arm all the time. They play, they go to school, and it is what it is. They will have experts who will say a broken arm is not worth $1 million. I'm just telling you that if you're spending a lot of time and effort to prove that you've $1 million in damages, they will have arguably proof that says no, you don't. And it isn't that you're not worth. It's not that you don't get $1 million. It's just that a judge can't give it to you on summary judgment. That's all.
I am aware of that. I understand that you have to operate within the FRCP and professional codes and things like that. So I will keep that in mind, Your Honor.
Please do. I just don't want you to waste your time, and I don't want you to waste the defendant's time. They're paying for it. You're not. But there's a cost to the public in terms of my time and my salary. Let's wait and see what you file.
Thank you, Your Honor, and I would like to...
Maybe the thing to do is to have you back within a week after the summary judgment is filed.
Mm-hmm.
And then let me hear from the defendant what their view is. I will have had a chance to look at it, and I think I can tell you whether you have any chance of going forward or whether this is really a situation that's going to necessitate trial. Because I don't want the defendant to have to spend time and money needlessly. So let's if he's filing the 16th, let's have him come back about January 3rd, 4th.
The 3rd.
So let's do January 3rd. And the defendant can then comment on, can discuss whether or not there should be a response or whether whether I can take the motion for summary judgment with the trial. So let's see where we go. It doesn't sound like I didn't realize liability. Have you talked? I assume there's no point in, but have you talked to counsel for the defendant about resolving this case?
Your Honor, if I may speak on that, I understand.
Briefly, Mr. LeBlanc.
Okay, I understand regarding the time and the monies that are put into cases and deliberating them and being assessed by both parties. I have, since the very onset of firing my attorney previously, of trying to settle with the defendants. So I've been attempting to do settlement conferences with them since 2016. And it was initially like, well, we don't believe you're going to get the surgery. And I presented the doctor bills and all that other things. And I've tried to consider the economics of both parties. So.
Mr. LeBlanc, too much detail. This is not helpful. What I'm going to tell you to do is I want you to have a telephone settlement conference with the defendant, at which time you will present to them why you think your case is worth whatever and make a demand. I don't care what your demand is going to be. It's a realistic and good faith demand. They can respond to you by saying, we're not interested. Or, gee, we didn't think about that. But I want to have, and I want you to do it right away, before you file the summary judgment papers. Call them today. You folks have had a lot of time since, 2015 in this case?
Yes, sir.
And they know the case. Pick up the phone and call counsel for the defendant. What time will you be available? Today, tomorrow? Or anytime today.
Your Honor, I'm sorry to interrupt, sir. I don't have the ability to contact him today. My schedule has other things for treating. And
how about tomorrow?
I can probably do tomorrow.
Okay. Call tomorrow in the afternoon, and then you'll talk. If they're not interested, they're not. They have the right not to be interested. If they think your price is too high, they can reject it. Maybe at this stage, you folks can resolve this. If not, we'll go to the next step. But I do think you should really at least try.
Your Honor, I am definitely open to and have always been open to. Like I said, it's on the defendant. I can only try so many times to come up with different offers and actually have the evidence to back up each of those offers. And, they haven't been interested. So I've been pursuing the legal course in which to do so. So
Mr. Blunt, you do what you can't do more than you can do.
Right.
And they have the right not to be interested. They can think that your injuries are not as severe as you. All I want you to do is try. If not, we'll continue on with the summary judgment.
Okay. Okay, Your Honor, I do have one question.
I'll ask defense counsel to give my chambers a call and just tell me whether it worked or it didn't work. I'm not interested in any of the details. I just want to know whether it's been resolved. I will assume it hasn't, but I think we should try.
Yes, Your Honor. If I may, that one question, I'm a little concerned as to doing this settlement conference because I have a motion for summary judgment coming by giving them the information you're asking me to give them. Isn't that, in essence, tipping my hand as to what?
You're going to have to give it to them the summary judgment motion. They can't change. Today is what day is today?
Tuesday.
They can't make Tuesday Friday. They can't make Wednesday Monday. They can't do anything to change reality. You're telling them what you're about to tell them on the 16th.
Okay.
The advantage.
Okay.
Right. Just
proceeding with caution, Your Honor. That's been my saving grace throughout this case.
Okay. Well, let's see what you do. You're going to be revealing various things in the summary judgment. If you tell them what's coming, they can't change reality. They can't alter the substance of things. So you're not hurting yourself. I think you should try.
Okay, Your Honor.
Of the seeming futility of it. All right. So we'll leave it as it stands now, except I'll hear from defense counsel after the conference. He'll let me know whether
one other thing.
Yes,
We have
to bar what?
I gave first copy
to me? Do I have it?
Yeah.
Okay, no, is it on the docket? I assume it's on the docket. Yeah, what number is it on?
143.
Okay. I'll have it run off. You don't need to. So you've got 143. Oh, yeah, and that came up with the information too late. Well, Mr. LeBlanc, do you know the motion he's talking about?
I do know the motion he's talking about, Your Honor, and that's what I was mentioning earlier is I had sent a motion to your chambers in regards to response to that.
I don't even know.
Yeah.
Okay, I'll look at those. If the material is too late, well, let me take a look and see what it looks like. Okay. Thank you all very much. Yes, sir.
think you have filed
because I don't have one.
You don't have it.
Right.
I would like to file a reply. You can have that.
Okay, how long do you want to file? A week? Two. All right, 2 weeks for the defendant to reply to the motion to bar. All right, December 20. That takes some Ricky, if we run Christmas into that, is that okay? Or you want more than 2 weeks?
If we can go until...
Yeah, January 2nd. 4 o'clock. Okay. And then just make sure my chambers get your courtesy copy, please. Thank you very much.
So we'll be back here on the 3rd. Prior to that, I will inform you about the conversation.
Yes. Let's go off the record for a second. Do you know, Mr. LeBlanc, as you sit here now, what your demand is going to be roughly?
Your Honor, since I'm sitting in my car, not off the top of my head, I don't have that documentation on me.
Well, what is the last amount that he's asked for? that you can ascertain? Yeah, sure.
I can't.
Okay. And have you guys made any offer to him? So you're free to do this. You're not really interested in settling the case, then? I mean, I don't want him to call you and have to go through the exercise of doing this for nothing.
You'd like to do that to say, and
okay.
Your Honor, I didn't hear any of that. I'm sorry.
He'll forward the information, your demand to his client. I just want your client to respond immediately, not to take 2 months to think about the law. Okay. Thank you very much. Mr. Blank, thank you very much.
Yes, Your Honor. Thank you.
Okay, bye-bye.
Hey, Your Honor.
Thanks a lot.